Last week was our first playoff game, and my plaque psoriasis was so itchy under all my gear. Sometimes just thinking about scratching could take me out of the moment. And then my doctor told me I could get clearer skin with a pill called Otezla.
Otezla apremilast is a prescription medicine used to treat adult patients with plaque psoriasis for whom phototherapy or systemic therapy is appropriate. Otezla can help you get clearer skin after just 4 months.
Okay, ready for the next game. Talking to my doctor about a pill was a total game changer.
Don't use Otezla if you're allergic to it. Get medical help right away if you have trouble breathing or swallowing, swelling of the face, lips, tongue, throat, or arms. Severe diarrhea, nausea or vomiting, depression, suicidal thoughts, or weight loss can happen. Tell your doctor if any of these occur and if you have a history of depression or suicidal thoughts. Live in the moment. Ask your doctor about Otezla. Call 1-844-4-OTEZLA or visit Otezla.com for prescribing info about cost, and more.
Richard Nixon.
Well, I'm not a crook.
Ronald Reagan.
Tear down this wall.
George W. Bush.
I can hear you. The rest of the world hears you.
And Donald Trump.
And a friend of mine for a long time, he only likes politics. If you ask him about how are the Yankees doing, he has no interest. If you ask him almost anything, he likes politics, and he's a professional at the highest level. Roger Stone.
All of these presidents relied on one man to secure their seat in the Oval Office. That man is Roger Stone. This is The Roger Stone Show on 77 WABC.
Welcome back, folks. I'm Roger Stone, and this is The Roger Stone on this beautiful Memorial Day weekend. As I said in the opening, our politics are extraordinarily volatile. We have seen a veritable tsunami of lawfare against President Donald Trump, cases filed against him in New York, 2 different cases in Manhattan, the so-called valuations trial that was over some weeks ago. Also now a trial wrapping up, the so-called hush money trial. You still have outstanding cases against him filed in South Florida pertaining to his handling of presidential documents, classified top secret documents. And there's still pending I guess it's an election interference case in Washington, D.C., in the D.C. jurisdiction. Joining us now is veteran criminal defense lawyer David Schoen. He is, to my mind, literally the most brilliant lawyer in the country because he's that rare lawyer who can look beyond the law, understands the law intimately, but can look beyond the law to understand the impact of external factors on any high-profile trial. The idea that the jurors will never see any publicity is quaint, but it's not a reality. And David Schoen has a big picture perspective that I have found very, very few lawyers to have. He very ably represented President Donald Trump on the Senate floor in one of the 2 impeachments. And it is our great honor to welcome David Schoen, criminal defense lawyer, to the Roger Stone Show.
Thank you very much. It's my honor to be here.
David, first of all, I understand you just won a very big legal victory in Baltimore. I don't know if you're able to talk about that case, but...
Sure. I appreciate very much you bringing that up. It's a very important case to me. I had the honor of representing a doctor, and my co-counsel, Chris Mead, represented his wife, also a doctor. And they were falsely charged with a HIPAA violation in aid of Russia, if you can believe that. They wanted to do humanitarian work in the Ukraine. They reached out to Ukrainian organizations, to the Russian embassy. They just wanted to save lives. They ended up getting set up by an FBI agent. So that by the 3rd meeting they had, trying to get over to the Ukraine, we saw an email go from the government prosecutor saying something like, well, I found something we can get them on. Let's try for a HIPAA violation. They asked them to produce some medical records. They brought in an old notebook, some patients, just to prove they were really doctors. And they arrested them, charged them with a felony HIPAA violation. with the intent to cause malicious harm or for personal gain. In any event, yesterday, the judge, a very fine judge, federal judge in Baltimore, Judge Gallagher, issued a 42-page opinion dismissing all charges against the defendants.
That is truly great, and it gives one some confidence that there still is justice within our judicial system. So congratulations on that. Let's move to the hottest news story on the legal front, and that, of course, is the ongoing Manhattan trial brought by District Attorney Alvin Bragg against President Donald Trump pertaining to these payments in a non-disclosure agreement that was executed by Michael Cohen, a former lawyer for Donald Trump. You made a very compelling case, I think it was on CNN that I saw it, that this is a fundamentally flawed indictment because there's no crime. You can't identify an underlying crime. Now, I'm not an attorney, but even I could figure out that even if Trump was responsible for the things attributed to him, which he vehemently denies, this would be a business records case, a civil business records case, which are normally adjudicated with a fine. But somehow Alvin Bragg, who campaigned, again, like Letitia James, the New York Attorney General, on quote-unquote getting Donald Trump, had this case bumped up to a criminal case. And Trump is facing felony charges. Can you explain this to us?
Sure. To the extent anyone can explain it. And I don't think there's any basis even for a civil case. I don't think anything was done wrong or against the law or in violation of any provision of the law. But here's what I mean from what I've said. First of all, I believe the indictment itself is constitutionally defective because it doesn't charge a crime. The way the statute works is under this 17510, it's called, the New York penal law, is that it's a misdemeanor to falsify business records with the intent to defraud. And then it becomes a felony if the person did that with the intent to commit or conceal another crime. So in this case, as you know, they tried to bump it up to a felony because they were past the statute of limitations for a misdemeanor. It's a very novel theory for good reason, because it doesn't make any sense. And in this case, they never identified what that other crime allegedly was that President Trump is accused of committing as the reason for falsifying the business records. And so it could be campaign finance violation, could be some kind of election interference allegation, a tax charge. They're all very different offenses. And without identifying that target crime, and it's the grand jury's job to identify it, not some prosecutor, without having the grand jury identify that crime, you can't possibly defend against it consistent with due process. There are double jeopardy concerns to be considered, but all kinds of Fifth and Sixth Amendment fair trial rights and New York State constitutional rights are violated when you can't know what you're defending against. The judge said in an order denying a motion to dismiss, well, the government's put out 4 theories about what it could be. That's exactly why you can't go forward with this. You can't be expected to defend against 4 theories. And you saw it all play out in the jury instructions. God only knows what to charge the jury because nobody has identified the crime. Now, here's some of these commentators saying, well, anyone who sat in the courtroom, Norm Eisen said it the other day, you sat in the courtroom, you know what the government thinks the crime was. I don't care what the government thinks the crime was, and neither does the Constitution. Constitution required the grand jury to charge a crime. What I mean, I'll wrap it up here, but on the other side of things is, I don't believe even the misdemeanor was committed. Based on the testimony we heard, the allegation is he falsely attributed business entries for money that was paid over to Michael Cohen as legal expenses. It sounds like it was legal expenses, certainly included in it, and certainly not calling it that would have a criminal nature to it. In fact, one of the witnesses early on, Davidson, testified wasn't even hush money. It was a settlement payment. The evidence was clear that money went to Michael Cohen, who was the lawyer. So nobody on earth, other than Alvin Bragg, who, as you say, ran on a platform of getting Donald Trump, would have come up with a cockamamie charge like that. It's an offense to our criminal justice system. But
David, isn't it kind of odd or unusual that the individual, Michael Coangelo, who was at one point the number 3 guy at the U.S. Justice Department in Washington in the Biden administration, would leave that august and important decision to become a prosecutor in a county DA's office in order to bring this case?
I think it is unusual, but not for someone who's obsessed with getting Donald Trump also. Look, we're seeing all of the stops pulled out here for political reasons in each of these cases. It's really astonishing, and it's offensive when the media doesn't call it for what it is. At least be honest about it.
A very good point. One of the things I wondered, if you look at the news coverage, you know that Fonnie Wills and Nathan Wade, prosecutors from Georgia, met with the legal counsel in the Biden White House, met with the Department of Justice. We know certainly that Jack Smith met with individuals in the Department of Justice and in the Biden White House. We know that Alvin Bragg and Fannie Wills both met with individuals in the White House and in the Justice Department. Is this not a racketeering conspiracy to interfere with the election? Because this level of coordination certainly gives one that impression.
It gives the American people that impression, and that's a terrible, terrible message to send. Why is this? Why is there this coordination among state and federal officials? And I don't want to hear from somebody in the media again, oh, there's always coordination. No, we're talking about targeting one person here who's the leading candidate for president during the election season, and clear coordination, people of the same political party as each other, Democratic Party, out to get Donald Trump. It's a complete perversion of the criminal justice system, and we can't survive that kind of thing in this country. I'm sorry to say. We have to be able to depend on the integrity of our governmental systems, but especially the criminal justice system. When the stakes are so high, people go to prison with misconduct by prosecutors, and especially when there's a political agenda. It's the absolute antithesis of what former Supreme Court Justice Robert Jackson said is the role of the prosecutor, a very famous article that he wrote many years ago.
Plan on flying? In order to board domestic flights, your driver's license or state-issued ID must be a real ID. Learn how to get your real ID today at tsa.gov/real ID or visit your local DMV.
So let's go to the actual trial. You were on this show, I think, several weeks ago, and you made a very strong case that Robert Costello, a former federal prosecutor, now a criminal defense attorney, very respected in New York legal circles, who had represented Michael Cohen at one time, no longer does. The privilege was waived in that situation, and therefore you made a very cogent case that Mr. Costello should be called as a witness by President Trump's lawyers. I think that his very, very compelling testimony before the House Oversight Committee by Mr. Costello, who's quite articulate, was a major factor in his ultimately being called as a witness in the Manhattan trial. Yet I was confused by the contretemps between he and the judge. Some have said that while Costello was a very effective witness for the president, he might have been more effective. I have a hard time reading what exactly was going on there.
Yeah, it's almost impossible, in my view, to have bungled this as badly as it was bungled. And still, even the Wall Street Journal acknowledged Bob Costello scored some strong points. But, I've gone back over the transcript. Here's what happened. The press just loves to report about the interchange between Judge Merchant and Bob Costello and the berating that Merchant gave him and all of that. First of all, I'll say this. I've been in front of Judge Merchant. I find him to be incompetent. I find him to be a bully. I find him to be insecure. In this case, add the extra element that he never should have been on the case, should have been recused as a matter of law because of his daughter's business dealings and so on. But put all of that aside for a second. He also hates Donald Trump. And so the idea for him, I believe, having a witness on the stand who was going to contradict a government witness and their primary witness, Michael Cohen, was complete anathema to him. So he was against Bob Costello from the start. But here's how things went awry. This is what has not been reported in the press. Prior to Bob Costello testifying, there was a sidebar, a meeting between the lawyers and the judge to discuss the nature of his testimony and objections that the prosecutor had to it. Even Merchant said at the time that he wished they would have brought this to his attention beforehand. These are complicated issues, he said, he believed. And so he stopped the trial, and he had the lawyers come in and start from scratch again to tell him what their objections were and what the basis was for calling Costello. He then entered a ruling severely limiting Costello's testimony. I think he was dead wrong on the evidentiary conclusions he came to. But putting that aside, he's the judge, and those were all subject to being appealed. But it skewed the deck, in my opinion. But anyway, he made a decision that the testimony would be very narrow. So he told that to the lawyers, but he never told it to Bob Costello. And the lawyers, this was, in my view, President Trump's lawyer, this guy Bove, who was handling Bob Costello, it was absolutely his obligation to tell the witness ahead of time that the judge has restricted testimony to the following subjects. Therefore, we have to be careful to follow his rules. As we go forward, I've lodged my objection already. He never spoke to Costello about it. President Trump deserves much better than that, because Bob Costello could have been the absolute star witness in the case had he been properly prepared, which he wasn't. They never properly prepared him for his testimony, and had he simply been instructed about the judge's limitations. And so what you saw happen was the lawyer, Bove, went into areas the judge had said he couldn't go into. The judge also was wrong with some of his rulings. But without having ever explained to Costello that the testimony can be limited, each time an objection came up that seemed to Costello relevant, he was surprised by the objection. And at one point, he said, geez, when an objection was sustained. The judge took great exception to that, which is also complete nonsense. And he cleared the courtroom. Now, in my view, had I been the lawyer in the case, I absolutely would have objected to that. It violated the Sixth Amendment right to a public trial. And as a consequence of that, other rights of President Trump, in my view. There's no record indication that the lawyer objected. The press objected to being kicked out of the courtroom.
Folks, if you're just tuning in, we're talking to legal superstar David Schoen. We're going to take a quick break, and we'll be right back with The Roger Stone Show.
This is The Roger Stone Show on 77 WABC.
Welcome back, folks. This is The Roger Stone Show, and we're talking to David Schoen, a prominent and widely respected criminal defense attorney. It was from David Schoen that I learned that there's a very substantial difference between a former federal prosecutor and a criminal defense attorney. They are not the same thing. I'm not trying to denigrate the legal skills of any particular former federal prosecutor, but as David points out, one has to be a strategist, a legal strategist, to do their very best, an obligation that goes along with their oath to do their very best to represent the interests of their client. But it's a different, more strategic way of thinking. David, much of the tsunami of lawfare against Donald Trump, this all comes in the fourth year of Joe Biden's presidency, which makes it all the more suspect. If, in fact, the president was guilty of any crimes, which I believe he was not, why were these cases not brought in the first year of the Biden presidency or in the first year after the Trump presidency ended? Does that in itself not point to a political motivation in these trials?
Absolutely, and probably the New York case is the sort of centerpiece for that analysis. I mean, you're talking about crime, an alleged crime that happened, the Stormy Daniels event. Let's just say that's the centerpiece of it. Then, you're talking about a mass not great 19 years ago, 18 years ago, something like that. Why wasn't that ever brought before? But you know what? They considered it, and they put a special prosecutor in, another Trump hater, Mark Pomerantz, in to investigate. And we know from his book that the people in the office just didn't believe this case should be brought, including at that time the leaders of the office. But still they brought it with a novel theory that never should have been brought. And all of the cases coming together at one time Of course, it's a political agenda. And anyone who says otherwise just really is not being honest or fair in examining the situation.
Yeah, as I said at the opening of the show, Michael Cohen went to the grand jury, was questioned about me. He made allegations about me in which it was alleged that he overheard a phone call between me and Donald Trump, candidate Trump, in 2016. First, he said it was July. Then he said it was August. The timing doesn't even make sense. By the way, it doesn't even fit the time frame of the allegations presented to the court by the prosecutors in my case. I think they looked at Michael Cohen and they determined that he was just not credible as a witness. All of these witnesses, whether it's Stormy Daniels or Michael Cohen, whose book is entitled Revenge, do they not hurt the government's case when their animus to Trump becomes so obvious and therefore their motive to potentially lie becomes so obvious?
Absolutely. I think from the beginning of this thing, starting with the Mueller investigation, all of that, if they really believe Donald Trump had done something wrong, and that's something important for the American people to know, why would you have to skew every single investigation for political gain? And that on the Mueller Commission, why would you have anyone like an Andrew Weissman anywhere near an investigation that must depend ultimately for its acceptance on its integrity? You wouldn't. But they only put sort of people, Democratic party contributors, and so on that. And we've seen it with every investigation so far. Jack Smith's got a very, very poor history of judgment, quite frankly. He ruined lives with cases he's brought. And that goes with people on his team. He's got a member of his team now named Cooney, who I've had a sanctions motion pending against quite a while, along with his group, other people who are on the Smith team now, lying to a federal judge to get email records from an attorney, and so on. It's just, this is not the way to go about it. We should have people who are completely above board, without any political agenda, investigating these cases. Had they investigated them, they wouldn't have brought any of these prosecutions. But you're right, it's a great disservice.
Well, you raise an excellent point. The chief prosecutor in my case had worked for Hillary Clinton, defending her and the Clinton Foundation in the so-called email server case. The number two in my prosecution had been a counselor to Hillary Clinton at the State Department. Incredibly, Robert Mueller himself testified before Congress that he had no idea that his own law partner, who was the chief prosecutor in my case, had represented Hillary Clinton and the Clinton Foundation, even though Hillary Clinton and the Clinton Foundation paid a very substantial amount of money to Mr. Mueller's law firm. It really does defy credibility. From the beginning, this has really been about timing. One of the things I'm not clear about is how the rest of this plays out. We have now a pending decision by the U.S. Supreme Court regarding the question of presidential immunity. That has now been argued. We're awaiting a decision. Many attorneys tell me they think, from a time point of view, that it's unlikely that that there can be another federal trial before the election. That would be the D.C. trial regarding election interference. They don't seem to believe that the U.S. Supreme Court can decide in time to schedule a trial that I guess would be, September, October. David, you have thoughts on this in the 2 minutes we have left.
Yeah, I assume that the Supreme Court's going to come down with this decision this month or next, obviously. And I believe that decision is going to be something like Nixon versus Fitzgerald. That is, that a president has immunity for an action within the outer perimeters of his official authority, an official act, something like that. That'll then have to be analyzed by the court. I believe Judge Chutkan, the judge who's presiding over the federal case in D.C., to which you're referring, would like to move this case forward as fast as possible. I have to be a little careful. I just won a case in front of her, I'm very proud to say, frankly. But I think that she really wants to bring this case to trial. I don't think, in fairness, it can be brought to trial before the election.
In the Georgia case, I guess at this point appears unlikely to go to trial before the election.
Right. You mentioned Fani Willis before. As you well know, the Georgia Court of Appeals now has agreed to accept the case. The presiding judge in the trial court did not disqualify Fani Willis. She did disqualify Nathan Wade. And now the Court of Appeals has agreed to consider whether he also should have disqualified Fani Willis.
All right. Unfortunately, we are out of time. I want to thank our guest, criminal defense attorney, David Schoen, legal superstar, in my opinion, for joining us today on The Roger Stone Show. Don't go anywhere, folks, because former Congresswoman Tulsi Gabbard, widely mentioned as a possible vice presidential candidate, is going to be joining us right here on The Roger Stone Show. Wow. In the meantime, David Schoen, thank you so much for joining us on today's show.
Thank you very much.